Good afternoon, everybody, and thank you for joining us for our final spring-summer session of the social housing webinar series. This afternoon's session is on affordable housing delivery and private sector investment. We are not going to be hearing from me today. So for those of you that know me, my name is Fiona McLeod. I'm a senior associate and I sit within the government regulation and competition team in Brodie's with a particular specialism in social housing. But the two speakers that we'll be hearing from today are my colleagues Jenna Munteith and Mellon. Jenna is a senior associate for Brodie. She has 10 years experience across the retail estate sector. With particular focus on public sector clients, including affordable housing providers, local authorities and non-departmental bodies. And Kirstine is a legal director for Brodie's. She has a master's in construction law and is dual qualified in Scotland and England and Wales. She has over 15 years experience in providing advice on all aspects of construction work in the private and public sector. So without further ado, I'm going to hand over to Jenna, who I believe is going to kick us off today. Thanks, Jenna.
Thanks very much, Fiona. And thanks everyone for attending this session today. We're going to talk about private sector investment in affordable housing. And just to kind of briefly set the context or the policy context here, Scottish Government published Scotland's first long-term national housing strategy in March last year, 2021, which was called Housing to 2040. And that sets out a route map, a strategy, which is aimed at ensuring that everyone in Scotland will have a safe, high quality home that is affordable and meets their needs in the place that they want to be by 2040. That was augmented by the current programme for government, which makes a commitment to deliver 110,000 affordable homes by 2032, at least 70% of those to be for social rent and 10% to be in remote, rural and island communities. Housing to 2040 does note that to deliver the ambitions around housing and the number of houses, the quality of houses, and in the location where these houses are to be, there would have to be a consideration of kind of innovative models to deliver those beyond the kind of very successful tried and true affordable housing supply programme mechanism. If I could see the next slide, please. Most affordable housing in Scotland at the moment is, like I say, delivered through Scottish Government's Affordable Housing Supply Programme, which is supported by a huge budget, around £3.5 billion for the financial years 2021 through 2026. And that support is provided to the different tenures of affordable housing, specifically housing for social rent, which receives the highest level of financial support, which is calculated in line with benchmarks, which take into account particular criteria such as the location of the housing, the size of the housing in terms of bed spaces. But it also supports the delivery of mid-market rent at lower levels, kind of reflecting the different rental incomes that are associated with social rent as opposed to mid-market rent, where the rents are a little bit higher. Social rented housing can only be operated by providers regulated by the Scottish Housing Regulator, and that includes, as you would expect, registered social landlords and local authorities, but only not-for-profit entities can be regulated providers, and that is kind of the key point here. And that makes Scotland quite distinct certainly from the position in England, where for-profit providers can and do deliver housing for affordable rent. But it does create a bit of a challenge in terms of trying to funnel in additional finance to support the delivery of the large numbers of high quality of homes that's required or projected to be required over the next few years. Could I see the next slide, please? There is more flexibility for non-regulated providers to deliver affordable tenures that are not social rent, so particularly thinking about mid-market rent housing, and that is, for anybody that doesn't know, housing which is leased at levels which is where the rent levels are fixed at slightly higher than social rent but lower than full market rent, and it's more relevant in some locations than others. It really depends on what the rent levels are in any specific location. For example, somewhere like Edinburgh, where the rent levels are, private rent levels can be very high. You know, the midpoint between full market rent, and social rents is quite significantly different or higher than a social rent, but lower than a market rent. There's lots of examples of different kinds of innovative models and structures, corporate structures, delivering mid-market rent across Scotland at the moment. There are many public-private JVs. There was a scheme, the National Housing Trust, which was operated and delivered by Scottish Futures Trust, which really promoted the mid-market rent tenure and delivery of that tenure through public-private partnerships. But more recently, we've seen public-public partnerships and many subsidiaries of regulated providers, so RSLs, delivering mid-market rent in the space, as well as some examples of private sector providers operating here at the moment. If I can see the next slide, please. So the point of all of this is to get to discussing private sector, how we can increase the opportunities for the private sector to invest in the delivery of affordable housing, to, like I say, to promote greater numbers of affordable housing being delivered in this way, and therefore to reduce the pressure on the affordable housing supply programme, and essentially to deliver more houses, more affordable houses, particularly with less reliance on public sector funding through that affordable housing supply programme. So what I've mentioned, lease-based delivery, and that is really the focus of today's presentation. And what lease-based delivery of affordable housing really is, it's a scenario where a private sector entity will essentially enter into a lease of housing with a housing provider, such as a registered social landlord or another affordable housing provider. And that affordable housing provider will operate that housing essentially as part of its own stock, and will be entirely responsible to the private sector landlord for the management and maintenance of that housing, and for the operation of it as affordable housing. So the lease arrangement would be between the private sector entity, who would be the landlord, and the affordable housing provider, who would be the tenant. The affordable housing provider tenant would then enter into occupational leases, either Scottish secure tenancies or private residential tenancies, with the ultimate occupiers, who would be living in these homes. There will generally be no upfront price payable because it is a leasehold arrangement, so there would be no upfront consideration. That would rather be split across the years, the number of years term of the lease, and payable as a rent. Can I see the next slide, please? The tenant, the affordable housing provider tenant, would have obligations in terms of the lease with the private sector landlord, and the lease would generally follow commercial, or the terms of a commercial type lease, as opposed to a lease which is more similar to a residential lease. The lease would be on FRI terms, which means full repairing and insuring, and really means that the affordable housing provider tenant would be able to occupy those houses as though they owned them in the traditional way, although they would continue to be owned by the private sector landlord. And the affordable housing provider tenant would be entirely responsible for the management and maintenance of the housing. The affordable housing provider would have obligations to the landlord, as you would expect, and those would broadly fall into two categories: financial obligations and non-financial obligations. The financial obligations would be clearly the payment of the rent, but also the affordable housing provider would be responsible for the other kind of financial items that are associated with land ownership, really. So, for example, if the site was affected by a title condition that required the affordable housing provider tenant to contribute to the maintenance of common grass cutting, or if there was an obligation to contribute to the maintenance of a common access road, then the affordable housing provider tenant would have to pay for those as though they were the owner of the site, and as they would normally do on sites which are kind of owned and operated in the normal way. Non-financial obligations would be principally the repair and maintenance of the asset. So typically that would be an obligation to maintain in good and tenantable repair and condition. But that would be broadly consistent with the landlord's obligation to his tenants to maintain the property to the appropriate standard. The rental payable in terms of the lease arrangement would be usually initially linked to a published measure of affordable rents, such as local housing allowance. So that would be the rent that's payable by the affordable housing provider tenant to the private sector landlord, and that rent would be indexed annually. The lease would usually be for a long term, so it would usually be 20 years plus. It might be as long as 40 years. It just depends on the underlying financial model, which would be devised usually by the landlord. And at the end of the term, the tenant would hand the housing stock back to that private landlord, unless the lease included an option to extend, in which case the term would continue for a further period, or, as is sometimes the case, an option for the affordable housing provider to purchase the ownership interest and then become the owner of that stock in the normal way and retain that ownership for as long as it wanted to do so from there on. If I could see the next slide, please. I think a key question that tends to come up when we talk about this is how secure the affordable housing provider's interest in the housing actually is. I mean, it's the difference between being a tenant in terms of a lease of this nature as opposed to being the owner in the normal way. But the affordable housing provider would enjoy what we would term in kind of real estate law terms a real rights in the housing leased. And that basically means that even if a private landlord was to sell its ownership interest to a third party, the tenant's interest would continue and would be a right against any third party that kind of sought to challenge the affordable housing provider's use and occupation of that property. So there is, the point is there is security of tenure, and because the lease would likely be longer than, for a term of at least 20 years and likely longer than that, the tenant's interest would be capable of registration in the land register. So the affordable housing provider would benefit from a land certificate in the same way as you would do if you had an ownership interest. I mean, clearly it is a lease, so I would be very remiss not to say that, or not to note that the landlord could bring the lease to an end if the tenant was in material breach of its obligations, and particularly in relation to the payment of rent. So if there was persistent or material non-payment of rent, then potentially the landlord could look to irritate the lease, which would ultimately be to bring it to an end. However, all commercial leases incorporate standard protections, and particularly around notice and obligations to notify prior to initiating irritancy proceedings. So it wouldn't be a kind of hard stop, as in, the affordable housing provider misses one payment of rent and the lease automatically comes to an end. There would be quite robust protections in place to protect the tenant from that situation. Could I see the next slide, please? The other question that's regularly asked when we talk about this is whether or not it's actually legal. Some people watching this webinar right now might be familiar with feudalism and the abolition of feudal tenure. I mean, feudal tenure essentially provided or created a scenario where there were large tracts of land and particularly housing, which was owned over in terms of very long-term arrangements by kind of land owners. And the occupiers never quite owned the property, and the property was always subject to the payment of a kind of regular financial obligation. And feudal tenure was abolished, and with that was generally the ability to enter into long leases of housing. However, the Land Tenure Reform Scotland Act made an exception to the general rule to permit social landlords, local authorities and their controlled subsidiaries. It permitted those entities to enter into long leases, specifically of housing. So it is perfectly legal for a social landlord, a local authority or their subsidiaries to enter into a lease of housing, albeit it's not generally permissible. As I've already mentioned, the tenant's interest in the lease would be capable of land registration and would be a real right, which would be capable of enforcement against any third party that was to seek to challenge that. On the housing, operational housing side, there is no prohibition in the Housing Acts to this type of arrangement. And actually, in terms of Scottish secure tenancies, Schedule 2 of the Housing Scotland Act 2001, which sets out the grounds for recovery of possession of a house, specifically provides that a court can order recovery of possession where the interest of the landlord in the house is a tenant's interest as opposed to an ownership interest, and that lease has been terminated or it will be terminated. So it was, is clearly envisaged in the regulatory sense that RSLs might well grant Scottish secure tenancies where they don't own the property that's occupied, but rather they lease that property instead. And I mean, so it is correct that it is legal, but I mean, definitely there are some practical issues that arise where it is secure tenancies that are being operated, particularly at the end of the lease term. We recognise that an SST is typically considered to be a kind of tenancy for life. So how do you, what happens at the end of that investor lease term when you have homes that are occupied? And I think that is clearly a practical challenge in this model, that's kind of inherent in this model in a way, but there are some ways that can be managed, and I think it is really a management issue as much as anything. One of the benefits of the leasehold arrangement is that there is a period of time which is known up front in terms of how long the leasehold arrangement will continue for, and so that in and of itself allows affordable housing providers to manage towards the end date, if indeed the lease does have a hard end date, as opposed to having an option to extend or an option to purchase the tenant's interest out at the end of the term. Could I see the next slide, please? So I think there are benefits for affordable housing providers to consider in a leasehold model. I mean, fundamentally, the key point has to be that this allows for the delivery of additional housing, additional in the sense of not being delivered through the Affordable Housing Supply Programme without a requirement for a significant upfront capital investment. And the point there really is additionality. It's about providing additional homes which may allow the traditional kind of grant spend that's available to be used possibly for retrofit or for other priorities around placemaking. The certainty as to the lease duration, as I've already said, allows for long-term management planning, and it allows for kind of normal programming of life cycle maintenance, and to allow towards the managing down of the asset at the end of the term, looking to recover vacant possession. And also to kind of stress the point that the affordable housing provider will have the control and management, the control of the management and maintenance of the housing, albeit that there is, a third party entity standing behind that as the landlord. The actual level of involvement by that private sector landlord would usually be minimal. The overall position in terms of a lease of this type of asset, as is very similar with other kind of commercial leases, would be that the landlord would be actively looking to pass on as much responsibility as is possible for the management and maintenance of the housing, and it wouldn't be the case that they would be kind of looking over the shoulder to see what would be what was going on a kind of day-to-day level. But the other key point to note is that generally customer experience for tenant occupiers would be unaffected. As I said, Scottish secure tenancies could operate legally through this model, but particularly private residential tenancies and short Scottish secure tenancies where those were appropriate would also work really well in this scenario, given that it's that bit easier to recover vacant possession in terms of those tenures. But for the actual tenant occupier, there would be no perceptible difference other than the fact that they would enjoy a nice new home, which they might not otherwise have the benefit of. Could I see the next slide, please? And I was going to hand over to Kirstine at this point to have a chat through some construction aspects of this kind of arrangement.
Thanks, Jenna. So I think it's firstly helpful to consider what the RSL would have the benefit of if they were procuring construction works directly, because that will set the context for what we'd expect as a package when the RSL is entering into a lease. So if an RSL were procuring the works themselves, then we'd be recommending a full suite of construction documentation is entered into. And by a full suite, I mean appointment of site investigation consultant or any other consultants for providing reports, a building contracts with the contractor, whether that's on a design and build or the more traditional basis, i.e. where the contractor's got limited design responsibility. We'd expect that would include performance security, depending on the covenant of the contractor, so a performance bond or parent company guarantee. Appointments of each consultant, so that would be the design consultants, such as the architect, structural engineer, services engineer, maybe a quantity surveyor, project manager, principal designer, and the employer's agent or contract administrator. And also subcontractor collateral warranties from design subcontractors, or those responsible for the material package of works. And that suite of documents would mean that the RSL would have contractual recourse in relation to the obligations of the parties during construction, but also for defects, including latent defects arising once the building has been completed. And we'd be expecting that that building contract would be based on an industry standard form, probably SBCC, with some bespoke contractual amendments which would clarify the duty of care in relation to design liability and would include additional obligations such as relating to the procurement of consents, responsibility for site conditions, compliance with additional design requirements. So for example, if there was requirements in relation to secured by design or the Scottish Government's energy efficiency standard for social housing, that would usually be made clear. And there would possibly be additional deliverables as well. So for example, if there was certificates required from a home warranty provider. And there would also be some provisions to provide some more price certainty to the RSL. In relation to the appointments, we'd expect those to be in a bespoke form. That's because the consultant standard forms, firstly, don't tend to be consistent with one another and therefore are quite difficult to manage if there's a lot of different terms. And secondly, they include fewer obligations and more exclusions and limitations of liability. The main purpose of the performance bond or parent company guarantee is to provide some protection if the contractor becomes insolvent during the build period. That bond would usually provide 10% of the contract sum, and that would give some funds to pay for the additional costs of getting another contractor on board. Now, if the RSL isn't the developer, then they're not going to be concerned in relation to the cost certainty of the build or just really how much that costs. There's not going to be an obligation to make rent payments until the works have been completed. And the level of rent won't be linked to the cost of the build. If the contractor becomes insolvent, then that would be a matter for the developer to sort out. So therefore, performance security won't be particularly relevant. However, the RSL will be responsible under the terms of their lease for repairs to the property in the event of defects. So it is important that there's a full construction package available to provide them with contractual recourse in the event of defects. And by contractual recourse, I mean that there would be reliance letters, for example, in relation to any relevant site investigation reports. There would be collateral warranties from the building contractor, from each of the consultants, and also from the design subcontractors. And what those collateral warranties would do is they would essentially warrant that those parties had complied with the obligations in the building contract appointment or subcontract, whichever is relevant, and that they'd used reasonable skill and care to be expected of a professional and competent designer of the relevant discipline. Without that direct contractual recourse provided by the collateral warranty, the RSL wouldn't have a right of recourse against the contractor and consultants in the event of a defect arising. The collateral warranty is, as indicated by the name collateral, to the underlying building contract, appointment or subcontract. So it's only as good as that underlying document. And that means that the RSL would want to carry out diligence on the underlying construction package by reviewing the legal conditions to ensure that they're in institutionally acceptable form, and provide for the expected protection. So some of the things that I mentioned there that you would be looking for if you were actually procuring the works yourself, you want to be in the building contracts if you're relying effectively on compliance with the building contracts via a collateral warranty. And the RSL would also be looking to double check that the technical annexations look appropriate for the nature of the works. If there was home warranty provider certificates, so for example, from the likes of the NHBC, then the RSL could also look to the benefit of those transferred on the basis that they should be entitled to make a claim directly in the event of defects being discovered. There's a few additional points I think to consider as well. So that's the kind of package of construction documents that you would be sort of left to run with, if you like, once the RSL was in the property under the lease. But any agreement for lease in relation to that lease, if you're getting involved when the works are being carried out, then you would also be wanting that to cover off some rights as well. So for example, variations, that would be variations both to the legal conditions of the building contracts and appointments that the RSL might have already approved, and also the specification. One would want to have rights of approval over those, or at least to the extent that there would be a materially adverse impact on the RSL. Practical completion. The RSL should have rights of inspection prior to practical completion being certified. The contract administrator should be bound to take into account their representations. Now, they could still certify if they considered it to be appropriate, but if the RSL disagreed with that, then there should be a right to refer to an expert. And then snaggings and defects. There will always be snaggings at practical completion. Those should just be minor. They shouldn't be things that would actually impact on the occupation of the building. If they were going to impact in that way, then that would really be something that should prevent practical completion occurring. But any snaggings, the RSL will want those rectified as quickly as possible. Now, the building contract would also usually provide for a 12-month defects liability period. That might be 24 months in some instances, given that some of the home warranty provider certificates, the kind of full cover doesn't properly kick in until after 24 months. But during that defects liability period, then the developer should be under an obligation to procure that any of the defects notified or rectified within the agreed timescales. And so we'd expect different categories for different types of defects, so emergency, urgent, non-urgent, etc. And we'd also usually expect there to be a protocol just in relation to entry for those repair works, and actually how that really kind of happens in practice, because obviously each unit is going to be occupied by the RSL's tenants. And as part of the diligence on the legal conditions, then it can be checked that the contractor is actually obliged to comply with those requirements. And I think I'll pass back to Jenna now.
Thanks very much indeed for that, Christine. So I think all I was going to do now was kind of draw the kind of formal part of the webinar to a close, and just really to note that it is, as I've already said, recognised that to meet affordable housing need, innovative approaches are required and are actively being considered. And private investors are keen, we know, to invest in affordable housing in Scotland because it has been a successful investment class for them in England. And within the current legislative framework, a leasehold model, such as we've been discussing today, does provide an opportunity for investors to place their funds in affordable housing in Scotland, while on the other side offering affordable housing providers an extra option to deliver additional affordable homes without significant upfront capital outlay. And with that, I think Fiona's going to come back on, and I think we're going to see if anyone has any questions.
Thanks, Jenna. Thanks, Christine. That was really interesting. I am going to kick off with one question that I have, and then we'll see if any other questions come in. But and it's really for you, Jenna. So you had mentioned that obviously an innovative approach has to be taken in order to provide the appropriate supply of affordable housing. And you mentioned that there may be circumstances where the RSL, will be leasing a property, so they may not own the property. So what would happen then in circumstances where a landlord goes bust or their lender was to take action against them?
That is a really good question, and I think that is one of the concerns for affordable housing providers that are thinking about looking at this route. But if the investor, landlord's lender was to call up, then because, as I mentioned, the tenant's interest is, the affordable housing provider's tenant's interest in the lease is a separate right in that land at that point. Even if a lender was to call up, the lease would continue to exist because it is a separate interest in land in its own right. So the ultimate, if the worst was to come to the worst, the landlord's lender was to call up their security and look to sell the asset, the lease would continue. The lease would continue for as long as the lease term will continue in terms of the lease. So if the lease is for 20 years and after 5 years, the landlord's lender calls up the security, enforces, becomes a heritable creditor in possession, and then looks to dispose, the lease would continue for the 15 years of the remaining term because it is a separate interest in land and exists on its own. I appreciate that sounds kind of odd because it is a lease, but the tenant's interest in the lease is a separate interest in land, kind of distinct from the landlord's heritable interest, and for that reason it would continue.
It's interesting.
Does that?
Yeah, that answers my question and is very interesting because I wouldn't have known that or thought that's great. I don't think we have any further questions at the minute, but what I would say is that in the event that you have questions that pop into your head later on today or further on in the week or another time when some of your colleagues are watching this recording of this webinar, contact details are on the screen, so please don't hesitate to contact either Jenna or Christine in relation to any of the issues that arose in the webinar today, or alternatively contact any of the three of us for anything social housing related. Please feel free to do so. As I mentioned at the beginning, that brings our spring-summer session of the social housing webinar series to an end. We are in the process of collating the autumn-winter series. So if you have any suggestions for a webinar, then please do get in contact with us to make those suggestions. There is a survey that will be sent to you at the end of this webinar recording. It'll only take about 30 seconds to complete, and one of the sections within that is suggestions for future sessions. So please do take the time to fill that out because it helps frame what we'll be providing you in the autumn. And other than that, all that leaves me to say is to thank you very much to Jenna and Christine for speaking this afternoon on a very interesting topic, and that we will see you all very, very soon.